Welcome to the State of Ohio Sexual Harassment Awareness Training, presented by the Ohio Department of Administrative Services, DAS, Equal Opportunity, EOD, and Human Resources Divisions, HRD. Trainings of this nature are important to ensure the State of Ohio remains a diverse, inclusive, and equal opportunity employer that promotes a safe and discrimination-free work environment. This training will focus on 3 key learning objectives. During this training, you will learn the difference between sex or gender discrimination and sexual harassment, and how both relate to broader equal employment opportunity, EEO law, and policy. The important concepts of sexual harassment in the workplace and what to do if you believe you are being harassed, and how to file an internal complaint and external charge if you have been a victim of sexual harassment or retaliation. It is important to have a basic understanding of the laws and policies prohibiting employment discrimination, including harassment. In this section, you will learn the basic requirements the State of Ohio must follow as an equal opportunity employer. Also, you will learn the difference between sex discrimination and sexual harassment, and how both relate to broader EEO law and policy. There are several federal and state laws and regulations which prohibit employment discrimination. A few of the federal laws and regulations include Title VII of the Civil Rights Act of 1964 as amended in 1991, Age Discrimination in Employment Act, ADEA of 1967, Americans with Disabilities Act, ADA of 1990, Title II of the Genetic Information and Non-Discrimination Act, GINA of 2008. The state laws and regulations are Ohio Revised Code 4112.02, Ohio Administrative Code 123, 1 through 49, Gubernatorial Executive Order 2019-05D, Anti-Discrimination Policy in State Government, DAS Directive H.R. 14, Anti-Discrimination and Anti-Harassment Policy and Reporting Procedures. Your agency also has its own EEO policy. These laws, regulations, and policies prohibit employment discrimination in state government and ensures the State of Ohio is an equal employment opportunity employer. Equal employment opportunity means that all employment-related decisions about an individual must be based on objective, non-discriminatory reasons. Due to the number of employees, the State of Ohio is an EEO employer under both state and federal law. An EEO employer may choose to protect more than what the law requires. For State of Ohio employment, the state EEO policy prohibits employment discrimination based on the protected statuses of race, color, religion, gender, gender identity or expression, national origin, ancestry, military status, past, present, or future, disability, age, 40 years or older, genetic information, sexual orientation, status as a parent during pregnancy and immediately after the birth of a child, status as a parent of a young child, or status as a foster parent. So, what is discrimination? Discrimination occurs when a negative employment decision is made based on an employee or applicant's protected class. There are 2 forms of discrimination. Disparate treatment. Disparate treatment occurs when an employer intentionally treats an employee differently because of their protected class. Disparate impact. Disparate impact occurs when an employment policy, although neutral on its face, creates a negative impact on a protected class. It is also discrimination to harass an employee due to their protected class, or to retaliate against an employee for opposing discriminatory practices, participating in the EEO process, or for requesting a reasonable workplace accommodation. Sex discrimination is a type of employment discrimination. Sex discrimination is defined as treating a person unfavorably or unfairly because of their sex. Sex discrimination includes pregnancy discrimination and sexual harassment. Pregnancy discrimination involves treating a female who is an applicant or employee unfavorably because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. If a female is temporarily unable to perform her job duties due to a medical condition related to pregnancy or childbirth, the employer must treat her in the same way as it treats any other temporarily disabled employee. Under state EEO policy, all employees and applicants are protected during pregnancy and immediately after the birth of a child. This is one of the 3 new protected classes covered under state EEO policy based on being a parent. Keep in mind, an employment policy or practice that applies to everyone regardless of sex can be a violation if it has a negative impact on the employment of people of a certain sex and is not job-related or necessary to the operation of the business. Harassment is a form of employment discrimination. Harassment is defined as unwelcome conduct based on a protected class, such as race, sex, religion, etc. Harassment becomes unlawful where 1, enduring the offensive conduct becomes a condition of continued employment, or 2, the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Petty slights, annoyances, and isolated incidents, unless extremely serious, will not rise to the level of illegality. Offensive conduct may include, but is not limited to, offensive jokes, slurs, epithets, name-calling, physical assaults, or threats, intimidation, ridicule or mockery, insults or put-downs, offensive objects or pictures, and interference with work performance. Harassment can occur in a variety of circumstances. The harasser can be the victim's supervisor, a supervisor in another area, or a coworker. A victim does not only have to be the person who is targeted for the harassment, it can also be anyone affected by the offensive conduct. While not a requirement under the EEO policy, if you feel safe doing so, inform the harasser directly that the conduct is unwelcome. The state of Ohio, as your employer, can be liable where it does not reasonably try to prevent and promptly correct harassing behavior. You should report harassment to management or human resources as early as possible. EEO retaliation is defined as making a negative employment decision about an employee because they engaged in an EEO-protected activity. This means that an employer may not terminate, demote, harass, or otherwise retaliate against you for filing a charge of discrimination, participating in a discrimination proceeding, or otherwise opposing discrimination. A protected activity is any activity where you have asserted your rights to or are participating in an EEO process. For example, filing or being a witness in an EEO charge, complaint, investigation, or lawsuit. Communicating with a supervisor or manager about employment discrimination, including harassment. Answering questions during an employer investigation of alleged harassment. Refusing to follow orders that would result in discrimination. Resisting sexual advances or intervening to protect others. Requesting accommodation of a disability or for a religious practice. Remember, when you participate in the EEO process, you have a right to be free from EEO retaliation. It should be noted that filing a claim of EEO retaliation will not stop pending discipline or termination. It will be up to your employer to demonstrate action was taken based on another reason. Now that you have learned the basic legal and policy requirements, let's look at specific concepts of sexual harassment in the workplace, including ways to identify it and what to do if you believe you are a victim. Here are a few things you may not know about sexual harassment. The victim, as well as the harasser, may be any gender. The victim and harasser do not have to be of the opposite sex. The victim can be a bystander or third party, and the harasser can be the victim's supervisor, a supervisor in another area, or a coworker. It is unlawful to harass a person because of their sex or gender. Sexual harassment means unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature, including offensive remarks about a person's sex or gender. In an employment setting, the conduct is either explicitly or implicitly a term or condition of employment. In other words, it interferes with the work environment through direct action or indirectly through the general environment. The distinction between invited, uninvited but welcome, offensive but tolerated, and flatly rejected sexual advances may be difficult to discern, but this distinction is essential because sexual conduct becomes unlawful only when it is unwelcome. Unwelcomed means the employee did not solicit or incite the conduct, and that the employee regarded the conduct as undesirable or offensive. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in a negative employment decision, such as the victim being terminated or demoted. Now that we have reviewed general concepts of sexual harassment, let's examine two types of sexual harassment: quid pro quo and hostile work environment. Quid pro quo is a Latin term meaning this for that, and occurs when an employer demands sexual favors in exchange for specified employment conditions. When submission to unwelcome conduct becomes the basis or condition of employment, the employer may be liable for harassment. A hostile work environment exists when a culture of harassment becomes tolerated in the workplace. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute a hostile environment when the conduct has the purpose or effect of unreasonably interfering with an individual's work performance, or creating an intimidating, hostile, or offensive working environment. Even though these two types of harassment are different, they are closely related. A hostile work environment may be created when a superior uses quid pro quo to force the victim to participate in sexual conduct, and that impacts the work environment or work performance. Further, if an employee or group of employees is consistently exposed to unwelcome conduct by a coworker or supervisor over time, it may become pervasive enough to create a hostile work environment. Unwelcome sexual advances or behavior of a sexual nature or offensive comments about one's sex can create a hostile work environment if the conduct is either severe or pervasive. Let's learn more about these two concepts. Consider it as a sliding scale in impact and amount. The more severe the conduct, the fewer times it must occur to be considered harassment. One time, if severe enough, can constitute sexual harassment. Sexual harassment becomes pervasive when it is tolerated behavior in the workplace. While there is no established number of incidents that defines unwelcome conduct as pervasive, the frequency, context, the nature of the harassment, and any attempts by the employer to take corrective action will be considered. A relatively small number of incidents reported over several years may not be considered pervasive. Sexual harassment usually becomes pervasive because the employer fails to address the issue, or because employees fail to report harassment in a timely manner. The reasonable person standard is a legal term used as a benchmark standard in harassment cases to determine if the harassing behaviors are sexual in nature or if there is a severe or pervasive hostile work environment. When using the standard, we will ask, would a reasonable person find this behavior to be sexual in nature? Or, would a reasonable person, given these circumstances, find this to be a hostile work environment? The reasonable person standard has two purposes. First, the reasonable person standard protects us from people who are hypersensitive. For example, A person may be legitimately offended by a coworker asking them out to lunch once and claim sexual harassment has occurred. However, a reasonable person would likely not be offended by such a casual request and would not consider the request for lunch sexual in nature. Second, the reasonable person standard protects us from work environments where the employees are desensitized to sexual conduct. For example, if a man begins working in a department that was previously composed entirely of women, and the man complains about the inappropriate photos and joking as part of the general work culture, we would not ask if those particular employees find it to be hostile. Instead, the question would be, would a reasonable person from outside of this workplace walk in and believe that it is a hostile environment? By applying a reasonable person standard, we protect ourselves both from hypersensitive and desensitized employees. Another important concept to understand in a sexual harassment case is the difference between the intent of the harasser and the impact to the victim. In harassment cases, it is the impact of the behavior, not the intent of the person doing the conduct, that determines whether sexual harassment occurred. Simply stating, "That's not how I meant it," even though it might be true, is an important factor but will not be enough to refute a sexual harassment allegation alone. To be clear, whether a specific behavior is unwelcome is decided by the victim or receiver, not the initiator of the behavior. Another note on intent concerns bystanders, who may not be the intended target for harassment. Remember, a bystander or witness may have a claim of harassment, even if the conduct or statements were not directed at them, because harassment can impact the work environment. In examining sexual harassment cases, sometimes the hardest part is identifying behaviors that could constitute harassment. The EEOC has categorized harassing behavior into 4 groups: verbal, physical, nonverbal, and visual. Verbal harassment. Verbal harassment occurs when employees engage in any of the following activities: using terms of endearment, slurs, asking for sexual favors, inappropriate jokes, name-calling, insults, spreading rumors, innuendos. Physical harassment. Physical harassment occurs when employees engage in any of the following activities: blocking, close standing, touching, groping, grabbing, hugging, kissing, sex, rape. Nonverbal harassment. Nonverbal harassment occurs when employees engage in any of the following activities: staring, leering, following, stalking, written communication, gestures, inappropriate self-touching. Visual harassment. Visual harassment occurs when employees engage in any of the following actions: displaying offensive pictures, drawings, screensavers, and emails in public view. Remember, conduct is severe or pervasive, not both. Impact, not intent, matters. It is based on the reasonable person standard. Conduct must be unwelcome. Under the State of Ohio policy, your agency as an equal opportunity employer has a responsibility to keep the work environment free from harassment and discrimination. In doing so, your agency should do the following: create a clear, concise anti-discrimination and harassment policy. State agencies should have an anti-discrimination policy that defines harassment and explicitly states harassment is not tolerated, explains the consequences, and sets forth a process for reporting and investigating complaints. Train employees about sexual harassment. It is recommended that employees receive sexual harassment training once per year, focusing on common situations that some employees might not consider to be sexual harassment but are. Managers should also be trained on their added responsibility and duties to keep the work environment free from harassment. Monitor the workplace. Managers should make it a regular practice to talk to employees and ask them about the working environment. Establishing a clear and open line of communication helps to maintain the message that the state of Ohio values harassment-free workplaces. Encourage employees to come forward. Agencies should adopt a reporting process that maintains as much confidentiality as possible. Creating a safe culture where employees know they can come forward without fear of retaliation is key to eliminating harassment. Take complaints seriously and investigate. Agencies should take all complaints seriously. If a formal complaint is made, the agency should perform a thorough investigation. If the complaint has any basis, the agency should take immediate corrective action. Now that you understand concepts and types of sexual harassment and what responsibility your agency has to you, let's review what you should do if you believe you are a victim of harassment. First, speak up. If you feel safe, say something. In many sexual harassment cases, especially those involving a hostile work environment, the alleged harasser may not realize that their conduct is offensive. In many cases, communicating with the individual will resolve the problem. If the issue isn't resolved, you have at least put the harasser on notice that you find his or her conduct offensive. Second, if the conduct continues, start documenting. Document your own work and communications in case the alleged harasser starts to question your work performance to justify their behavior. Document the alleged harassing conduct each time it occurs. When you document, be sure to make note of the time, date, who was involved, what happened, the impact to you, and any outcome because of the conduct. Documenting the harassing behavior will be helpful in assessing severity and pervasiveness. Third, you can talk to your direct manager, EEO officer, Human Resources HR Administrator, or DAS EOD. What if the offensive conduct doesn't stop, or the harasser tells you he or she doesn't care what you say or put in an email? All members of the management team have responsibility for addressing harassment issues brought to their attention. Even if the manager is not your direct supervisor, they have the responsibility for addressing any issues that come to their attention. After you speak to a manager, document your conversation immediately. Fourth, remember to follow your agency's policies and procedures. Every agency is required to have policies and procedures for addressing harassment. If you have any questions about the procedures, contact your manager, EEO officer, HR administrator, or DAS EOD. Lastly, file a complaint. It is hoped that once the management team is involved, the issue can be resolved quickly. But if not, you have the option of filing a complaint. We will discuss how and where to file in the next section. If you need to file a complaint based on discrimination, harassment, or EEO retaliation, we will review the process in this section. There are two types of complaint processes. Internal complaints allege violation of state and agency EEO policy, and external complaints allege violation of federal or state laws. You may file internally, externally, or both. Investigations and determinations may be issued in both processes. As a state employee, the instructions on how to file internally are provided in your agency's EEO policy. One internal option outlined in your EEO policy is to file with DAS EOD, which administers the internal discrimination complaint system for the state of Ohio. This option is an internal and formal option. You will have 30 days from the last date of discrimination, harassment, or EEO retaliation to file. Another option is for your agency to conduct a review as an internal and informal investigation. You also have the right to file a complaint externally. You can file with either the Ohio Civil Rights Commission, OCRC, or the United States Equal Employment Opportunity Commission, EEOC, or both. The difference between the OCRC and EEOC centers on court systems and filing deadlines. In some cases, filing with one will automatically file you with the other. To file a complaint with the OCRC, you must do so within 6 months from the last date of discrimination, harassment, or retaliation. Visit the OCRC at crc.ohio.gov to learn how to file a charge and view additional resources. To file with the EEOC, you must file within 300 days of the last date of discrimination, harassment, or retaliation. Visit the EEOC's website at eeoc.gov to learn how to file a charge and view additional resources. We encourage employees and applicants to consider beginning with the internal process. You may ask yourself, what is the benefit of filing internally? First, filing internally allows your complaint to be addressed faster. With a 30-day filing deadline and 60 days for a typical investigation, you may experience a more immediate impact to your work environment. Second, filing internally allows for a holistic approach to resolving issues and promoting a work culture free from discrimination, harassment, or EEO retaliation. We have an interest in promoting diverse, inclusive, and equal work environments for everyone. Filing internally allows DAS-EOD and your agency to identify broader work culture patterns, partner with other state resources, and find immediate solutions for improvement. Third, as state employees, we are invested in you. We want you to be a productive and engaged employee. By filing internally, this gives us the opportunity to be proactive in how we address issues. Remember, filing internally does not prohibit you from filing with the OCRC or EEOC or both. If you decide to file internally, it is important for you to understand your rights during the process. You are entitled to be accompanied and advised by any representative of your choosing. Request an external investigator be assigned to your case if you believe a conflict of interest exists with having your agency EEO officer assigned. Receive notice of your right to file this same complaint with the OCRC or EEOC, how to file, and filing deadlines. For DAS-EOD to consider your complaint, it must meet a few requirements. First, who are you? At the time of the incident, you must be an employee or applicant for employment with the state of Ohio. Second, what happened? You need to know what type of case you are filing: discrimination, harassment, or EEO retaliation. You may file in just one category or as many as you believe are implicated by the facts. Remember, cases must involve an employment-related decision. Third, what protected class was involved? One of the protected classes must be implicated in your allegation, meaning the accused has acted because you are of a certain race, gender, religion, etc. For sexual harassment cases, gender or sex are the most commonly selected statuses. Fourth, when did it happen? Did the last incident happen within 30 days of the complaint being filed? For harassment cases, even if the issues have been going on for a long period of time or is pervasive, the last incident must have occurred within 30 days from the date you file. If you are unsure of one or more answers to these questions, you can take advantage of a counseling session with either your agency EEO officer or a DAS-EOD program officer. During the counseling session, you will receive information and resources about types of complaints, the process for filing, and assistance in answering your questions. Ultimately, the decision to file a complaint is yours. When you are ready to file your complaint with DAS-EOD, you can visit either the myohio.gov portal or the Ohio DAS webpage. If you do not have access to a computer, you can also go to your agency EEO officer or call DAS-EOD to have someone complete the online form for you. To file a complaint through the myohio.gov portal, go to myohio.gov, enter your State of Ohio employee ID and password. Click My Life and Career. Click File a Discrimination Complaint. After clicking, you will be directed to the Discrimination Complaint Management page. This page contains information reviewed in this training and instructions on how to file. Please read through everything. If you have questions, contact your agency EEO officer or DAS EOD. When you are ready, click on the hyperlink under Steps to File an Internal Complaint of Discrimination, which is near the end of the page. The link will take you to the online complaint form, which is directly connected to the State of Ohio Internal Discrimination Complaint System. To file a complaint through the DAS website, go to the DAS website at das.ohio.gov. Select the File a Discrimination Complaint link under Hot Links in the bottom left of the page. When you are ready, click on the hyperlink under Steps to File an Internal Complaint of Discrimination, which is near the end of the page. The link will take you to the online complaint form, which is directly connected to the State of Ohio Internal Discrimination Complaint System. Once a complaint is submitted, DAS EOD will determine if the complaint requirements are met to accept your case. If the requirements are not met, you will be notified that your complaint has been rejected and given information about how to file with OCRC and EEOC. If accepted, you will receive a jurisdictional determination letter describing what will be investigated. Once assigned, the investigator has 60 days to investigate. If the investigator needs additional time, they may request an extension. You will be notified if an extension is granted. Once the investigator has completed the investigation, the agency will issue a finding. A finding means the agency has determined both the factual finding and whether a violation of state and agency EEO policy more than likely occurred. Once the agency has made its finding, it will inform you of the determination and how to appeal. You may file an appeal with EOD within 15 days of receiving the findings report. You may file an appeal based on 1. Lack of thoroughness in the investigation, 2. Misapplication of agency's EEO policy and procedure during the investigation, and/or 3. Blatant disregard or violation of state EEO policy resulting from a finding. Appeals will not be granted based on a factual disagreement or disagreement with the investigator's judgment of witness credibility. Once DAS EOD receives your appeal request, it will be accepted or denied. If the appeal is denied, you will receive notice and information on how to file with OCRC or EEOC. If it is accepted, DAS EOD can take one of 3 actions. 1. Send the case back to the agency for a supplemental investigation. 2. Order the agency to take corrective action consistent with EEO law or policy. Or 3. Order a hearing. If you have questions about the content of this training or other questions on employment discrimination, harassment, or EEO retaliation, please contact Department of Administrative Services, Equal Opportunity Division. Affirmative Action, Equal Employment Opportunity Unit, 614-466-8380. das-eod.aaeeo@das.ohio.gov. Thank you for participating in this training and supporting the State of Ohio in fulfilling its mission to remain a diverse, inclusive, and equal opportunity employer.